Good morning. I would like to welcome you on the next episode of Legal Coffee. Today we will be discussing a very interesting topic which refers to privacy, personal data protection, and the situation between EU-US in this area. My guest today will be two gentlemen from US, Christopher Fulmer, and from Italy, Jakob Tasser. I said Jakob, but maybe your Italian name sounds, we shall pronounce in a different way.
Perfectly fine.
Christopher is an attorney from Morningstar Law Group of North Carolina, and he's a tech lawyer and a business attorney with broad experience in technology. Jakob is IT lawyer too, professionally specializes in the area of privacy, e-commerce, and data protection. He works for Plattner, law office in headquarters in Bolzano. So we have two different insights from US perspective and EU perspective. Good morning.
Good morning.
Can you tell me, because lots of organizations collect personal data in many areas during the regular business operations. It happens in Europe and in US too. So are there special regulation in EU in reference to data protection, Jakob?
Yeah, of course. I mean, the most recent one and very well-known regulation is the GDPR, General Data Protection Regulation, which introduces a whole swath of principles and rules dealing with the protection of personal data, especially when it comes to processing. And as far as our discussion today is concerned, obviously as concerns the transfer of data from the EU and by extension the EEA to third countries, such as, for example, the United States.
Mm-hmm. Is there a federal privacy act which refers to data protection in USA, Christopher?
There is really no one law in the U.S. that is equivalent to the GDPR. The U.S. approach to privacy has tended to be sector-based. Excuse me. So we have protection for health information, for example. Your doctor cannot tell just anybody what your prescriptions are or your medical condition. We have protections for banking information. Your bank has very strict guidelines over what it can do. And various states have laws. Most of them apply only to commercial enterprises. California is probably the best known, that restrict what can be done with personal information of people in those states. But at the federal level, encompassing everybody, there really is no privacy law. It's a mishmash in different areas, different jurisdictions, but nothing equivalent to the GDPR.
Mm-hmm. Do you think that EU and USA has a different definition of a key data protection concept? When I'm listening to you, that looks that GDPR is a kind of regulation which applies everywhere. Christopher said that you have different state regulations. But how about this a general attitude to data protection? Maybe we start in USA right now.
Sure. So the U.S. The U.S. has a different history than Europe does. In general, U.S. concerns for privacy have played second to other U.S. values, particularly the right of free expression. So, the U.S. does not have an intrinsic privacy ethic, I would say. Yeah, I mean, we do have laws protecting privacy. The police cannot come into your home and search it without a warrant, for example. There are limitations to searches of your information by the federal government. Interestingly, those tend to apply only to U.S. persons, and those rights do not extend to people who are in other countries, and that's one of the reasons why the EU and the U.S. seem to be constantly talking about privacy. U.S. law, where it does apply, applies mainly to U.S. people, not to folks in Europe. In contrast, Europe would very much appreciate it if the U.S. would protect personal data of Europeans.
Mm-hmm. Okay, so Jakob, how it looks? It looks we as EU citizens and you as statutory are more focused on personal data protection. Yes.
Yeah, definitely. I mean, I think one could argue that the right to privacy really started or originated from the U.S. in the U.S. Right? I mean, the famous article by Warner Brandeis from 1890 that sort of came up with this negative aspect of the right to privacy. So the right to be left alone, basically. And there's a very interesting, very famous case law, the Olmsted case, for example, that really applied this right in its connection with property, really, right? So basing it on the Fourth Amendment, if I remember correctly. This sort of migrated over to Europe, where it was picked up first by the not by the European Court of Justice, but initially by the European Court of Human Rights, which obviously has a right to privacy, to private life, Article 8 of the European Convention on Human Rights, and was then actually, again, picked up by the European Court of Justice, that has really broadened the scope of privacy, and especially since the introduction of the European Charter of Fundamental Rights, the right to data protection is a fundamental right in itself. So we don't only protect the right to private life, so Article 7, but also the right to data protection. And because Chris mentioned the right to freedom of expression before, I mean, just to give you an idea of how serious we here in the old world take the right of data protection, there are certain cases, such as, for example, the Google Stain case of 2012, where the European Court of Justice actually held that the right to data protection prevails in certain instances over other fundamental rights, such as the right to freedom of expression, for example, where the issue was that of de-indexing Google searches, for example. So this maybe gives you some clue as to why we're still butting heads when it comes to issues such as privacy, especially when it comes to privacy, leaving Europe and going over the Atlantic to be stored on U.S. soil. So that's where we're at right now, and that's, I think, what we want to discuss today.
Yeah, and that could be a reason why in GDPR we have so many restrictions, yes, in reference to data transfer to US, because probably EU thinks that the protection is not adequate in the EU system. So why do you think it's important to start to work over these regulations, which combine to completely different system and completely different mindset, even, I think, to protect them in the same maybe level or similar level, yes, accepted for both interested parties? And maybe Jakob, you can start with something.
Well, because obviously transatlantic trade is of enormous interest to both the U.S. and Europe. I mean, I think we're talking of amounts that are in the trillions of dollars each year. So obviously there's some interest by all parties concerned that this issue be resolved. Also, many of the major cloud providers, for example, right, are established in the U.S. So there's not just an interest when it comes to the protection of personal data of European citizens being maybe potentially subject to, let's say, surveillance by U.S. Intelligence services, but also simply the issue of European companies having to rely on the services provided by major U.S. cloud providers, for example. Mm-hmm. So that's definitely something that drives this issue and which is to come up again and again, right?
And Chris, from your perspective, how it looks, why it's so important to do this?
Well, Jakob is exactly correct. I mean, there is an enormous amount of trade there. The benefits of data flows between the U.S. and the EU are enormous. Most of the large technology providers are located in Silicon Valley in the U.S. We have Google and Facebook, and Amazon is right up the road. And anytime you are dealing with technology that involves connecting people to each other, or any sort of social media, or even any sort of widespread, let me help you figure out what you want to buy, those sorts of things always include personal data. And it's natural to be concerned with what happens to that personal data, especially, and I think from the European perspective, you might be more comfortable with a company who is based up the road from you having your personal data than with a company that's based literally across the ocean and then further across a continent, who seems kind of nameless, and you know that they are massive and are collecting a lot of personal data. So the data flows are important. Protecting the rights and expectations of people about what's going to happen with their data is important. Now, interestingly, those expectations tend to be different in the U.S. than they are in the EU, and that's where we're seeing a bit of a conflict right now.
Yeah, but still the development of a technology somehow pushes us, yes, to think about it more and in more detail, even if we thought before in a different way. So before we go to the executive order, which may change a little bit situation, and start and open a new discussion. Let's get back to the history. Yes, how it was in the history. If you could, Chris, say a few words about this in relation between EU and US and data flow system.
Sure. So yeah, it's possible to go back, centuries. I'm not going to go back that far. I will go back to kind of the most recent activity, starting in, well, this is 30 years ago now almost. I mean, 1995, the EU issued the Data Protection Directive that established some fundamental rights of EU citizens with regard to their personal data. And one of the things that it required was that if you're going to be sending information to a foreign country, then that information, then that country's laws needed to provide an adequate level of protection for that data, needed to adequately protect the rights of the people who were involved. U.S. law at the time did not have that, so there's an international agreement that came up with what was called the EU-US, or maybe it's the US-EU, I don't remember, safe harbor, by which U.S. companies could certify, yes, we are protecting personal data appropriately. They make certain commitments, and if they do that and they certify, then those data flows can happen. That worked well until that went into effect in 2000, I believe, and it worked well for a number of years until I believe 2015 or 2016. I don't remember the time exactly. When an Austrian named Max Schrems sued Facebook in front of the Irish Data Protection Authority, claiming that Facebook was not adequately protecting its data. That case made it to the European Court of Justice, and the European Court of Justice said, "Oh, the safe harbor that doesn't adequately protect personal information," and threw it out. So then the various governments between the EU and the US said, "This is a disaster. We need to fix this," and they came up with something called the Privacy Shield, which imposed further restrictions. Further restricted what the U.S. government could do in its signals intelligence, and then the EU determined, well, that was an adequate level of protection, and that lasted for a few years until Max Schrems came along again in Ireland, and then we had a case known as Schrems II, which invalidated the Privacy Shield. So we're now in a post Schrems II world. And what we're seeing is another attempt by the U.S. to address the issues that the Court of Justice raised in Schrems II, to once again find that the U.S. adequately protected that personal information. So we are in the middle of that process. President Biden has issued an executive order to implement that, and we will see how things progress from here.
Jakob, would you like to add something to this story? We have a long story between US and EU, a few a safe harbor and a few judgments.
Sure. Maybe just a couple of points, because this is relevant then for our discussion later, where we touch upon the executive order, the general attorney's regulation, and the draft adequacy decision that just came out back in December. Maybe when it comes to Schrems I, that's a very good example, I think, again, of that shift by especially the European Court of Justice away from merely what we could call them economic considerations, right, over to an interpretation that has to be made through the lens of European Union treaties and charters, right, and fundamental rights. So actually, the Data Protection Directive of 1995 was based on economic considerations and actually adopted a market-based approach where the goal that it tried to achieve was really to facilitate data flows, right? The European Court of Justice actually picked that up in Schrems I and said, no, Article 25 of that directive, which introduced the concept of adequacy and being able to transfer data to third countries, established the adequacy requirement, where it said protections in a third country have to be adequate. The European Court of Justice in the Schrems I case, for example, said, well, yes, it is true, they have to be adequate, but our understanding of adequacy actually has to align with our fundamental rights. So the
definition is completely different of
adequate. Yes, exactly. So they said, because as you know, just to give you some more historical context, maybe Schrems I really came about or was prompted by the revelations made by Edward Snowden of these quite scary mass surveillance programs going on in the US, of which personal data of European citizens also were affected. So just to get back to my point, what the European Court of Justice said is that for there to be adequacy, the protections afforded in a third country such as the US have to be essentially equivalent, not identical, but essentially equivalent to protect the fundamental rights and freedoms of data subjects. And that's something that we're going to see will come up again when we discuss the recently adopted executive order. And in Schrems II, they, always based on the findings that they already made in Schrems I, actually also considered other or two different fundamental rights, which are enshrined in Articles 47 and 52 of our charter, which is the right to a legal redress, to effective legal redress, right? So that I actually have actionable rights as a data subject, and the principle of necessity and proportionality. So basically what they said in Schrems II was that even a privacy shield did not set up a system by which a data subject based in Europe could actually have meaningful redress or meaningful recourse in order to achieve protection of its data subject rights in the US, because the old ombudsperson system that had been set up under the Privacy Shield regime was really not independent in any sense of the imagination, you could say, and was really just an expression of the executive branch. And again, when it comes to proportionality, what they said was that data surveillance being carried out by a U.S. intelligence agency was in no way proportionate to the goals that they actually tried, or to purposes of the data processing that they were carrying out. So, I mean, I hope I've been clear. If you have any additional follow-up questions, please feel free to.
Yeah, I think that maybe we'll make it a little bit systematic. So we mentioned the executive order. It was at the beginning, and right now it's mentioned several times. So, Chris, if you could say us a few words about what it is and what kind of influence it can have on this data flow between EU and USA.
Sure. So let's back up a little bit to the Schrems II decision. The meat of that decision was based on concerns with U.S. what are called signals intelligence, so intercepting communications. And the concern was that the U.S. intelligence agencies, as Jakob mentioned, were not using data in proportion to legitimate use, and that Europeans really had no means of redress for how U.S. intelligence agencies were using their data. It doesn't matter what a company agrees to, if the government can kind of go behind their back and look at the wires as the data flows from country to country. No agreement with a company will restrict the government in that. So the executive order seeks to solve both of those problems. And what it does, it orders the U.S. intelligence agencies to basically only collect data to the extent that the collection is proportionate to a legitimate national security interest. And there are various review mechanisms that are put into place to ensure that that's happening. All of those review mechanisms are secret. I mean, these are spies we're talking about, and they don't really want to publish what they're doing. So various mechanisms in there to try to make sure that only the intelligence that's actually needed for a legitimate purpose, and those legitimate purposes were it was law enforcement, quote, the public interest. I'm not sure exactly how that's defined, and then legitimate intelligence purposes. I don't remember exactly the language, but that's a sort of thing that they had. So that was one thing. And then the second thing was that they put into place a mechanism by which a person in an affected country, which in this case would be the countries of the EU, could complain to the Civil Liberties Protection Officer of the U.S. intelligence apparatus, and say, I think you've been using my personal information not in proportion to a legitimate use, or have otherwise been abusing that, and the Civil Liberties Protection Officer would then go and investigate, and had the authority, if he found a problem, had the authority to order intelligence agency to change its practices or to stop doing something. There's a review mechanism inside there, which would consist of a panel of judges from outside the government to review allegations. There'd be somebody appointed as a representative of that European citizen to appear before that court and make that person's arguments for them. But all of those deliberations, all of that is secret. So the citizen would get a response back saying, "Thank you for your complaint. We have investigated, and we have either determined that there was no problem, or we fixed the problem." But it won't say which one of those it was. It'll only say we've done one of these two things, and you're okay now. In theory, that's the ability to look for redress. In practice, I don't know that very many people on the European side are going to be satisfied with that.
Yeah, that's my concern too. Yes, although this order was definitely drafted in order to address the concerns, yes, raised in Schrems II, but still not sure if that's adequate enough when you think about the adequacy. Jakob, can you tell me what's in the draft adequacy decision, and what does it say?
Yeah, sure. Maybe just to back up a little first, maybe some of our listeners are not familiar with the concept of an adequacy decision or what that entails. So just a quick reminder for everyone, an adequacy decision is now a tool envisioned by the GDPR, right, which allows the transfer of personal data from the EU to third countries, which, in the opinion of the European Commission, provides essentially equivalent protections of fundamental rights and freedoms of data subjects. We've had several adequacy decisions in the past. Two have already been struck down, for example, when it comes to the US, the one from 2001 from 2016, Privacy Shield. Now, as a consequence of the executive order and the general attorney's regulation, which was really the result of the meeting of a lot of negotiations between the EU and the US. I don't know if you remember, back in March 2022, I think it was, EU Commission President Ursula von der Leyen and President Biden actually met and sort of tried to come up with a timeline and a rough play idea of what this new data privacy framework would look like. Well, now with the executive order and the general attorney's regulation, we have this new data privacy framework, and it is now the European Commission that has to actually decide if this new framework meets the high level of protection required for data transfer to be lawful and fair again. And maybe something that I should add is that once an adequacy decision has been made, you don't need any other safeguards or authorizations in order to freely transfer data from the EU to the US. So what does the draft adequacy decision actually say? Well, it goes over in quite meticulous detail the contents of those two orders and regulations. And it essentially concludes that it meets the standards, especially the necessity and proportionality standard, which was outlined and highlighted in the Schrems II case, if you remember, and the meaningful redress requirement. It was also outlined in the Schrems II decision. And it therefore sort of kicked off this adoption process, which is still ongoing, that will eventually lead, hopefully, to a final adequacy decision. We still don't know why. We can only make assumptions. Maybe we can touch on that later. But the adequacy decision fundamentally is, what would you say, rubber stamps the data privacy framework that was established now with the new executive order, and is now in the process of gathering opinions, gathering additional information from other European institutions, such as, for example, the EDBP, so the European Data Protection Board, which should fairly soon come out with an opinion on this draft adequacy decision, and it will then collect opinions by representatives of the single member states. Even scrutiny by the European Parliament is considered. So I should maybe add that all of these institutions can make opinions that are non-binding to the EU Commission. So regardless of what they say, regardless of what concerns they may raise, ultimately it is in the exclusive purview of the EU Commission to adopt this decision or not, and then maybe leave it up to the EU justice system to strike it down again. We still don't know. That remains to be seen. Yeah, I don't know if we want to address the concerns right away.
We try to summing up the topics and challenges. If you could give me some insight from US perspective and EU perspective, just in a few sentences. Yes, maybe we start with Chris. With what might happen, what we expect, what we want, in few sentences.
Well, the U.S. would be very happy if the adequacy decision were to be issued. If any attempt by Max Schrems to counteract it would fail, and if we would have a permanent solution to this problem. There is a lot of belief in the U.S. that that's unlikely to happen. Mainly because we've had two adequacy decisions knocked down before, and it's beginning to feel a little bit like that may just be the permanent state of affairs. You pick one up, knock it down; pick another one up, knock it down. This is the third one. So there's skepticism, but there is hope that maybe this will be the one that actually works.
Not very optimistic, Jakob. How it looks from your perspective?
Well, I'm cautiously optimistic that maybe the decision itself will be adopted. I totally agree with Chris that it will certainly be challenged. I mean, the same day that the draft resolution was published, our colleague, Maximilian Schrems, came out gate swinging and said that he's ready to challenge it again.
He's already preparing for it.
He's willing to challenge it again. And I mean, there are certainly some concerns with the data privacy framework. For example, we addressed the new recourse mechanisms that have been introduced. Now, we especially focused on recourse mechanisms when it comes to processing of personal data by U.S. intelligence agencies. There's a different recourse mechanism for organizations that have just get a certification, just like they did under the old privacy shield, right? But staying with recourse mechanisms for U.S. intelligence agencies, I mean, the effort by the U.S. must certainly be applauded. I mean, there are many steps, many mechanisms that have been introduced. Chris talked about the Civil Liberties and Privacy Officer earlier, which, correct me if I'm wrong, is able to make binding decisions or decisions that are binding on U.S. intelligence agencies that can maybe appeal this then to this new body that has been established by the General Attorney's Regulation, which is the Data Protection Review Court, right? And I mean, just when we talk about or look at the way those judges are being appointed, I mean, they have to follow the same mechanism and tick the same boxes that federal judges have to comply with in order to be appointed. And they can, I think, only be dismissed for cause, which is certainly something that will give them additional independence. So they can only be dismissed in case of, I think, inability to perform and various different criteria. At the end of the day, it still remains to be seen if this is a court, right, in the sense or in the understanding of the European Union, and especially of Article 47 of the European Charter. Just to give you an example, this is still a body that has been appointed by or established by the executive branch of the government. This is basically a form of administrative review, so this is not really judicial review in any meaningful sense. And it can be struck down just as easily or removed just as easily as it has been established or introduced, right? I mean, we're still talking about a regulation and an executive order. Now, those are not pieces of like the legislation, so there's certainly some concerns that maybe with the new administration or potentially a new administration coming in 2024, that these executive orders might be overturned, just like they have been in under previous administrations. Think of Obama's executive orders, for example. Now, also, the mechanism sounds kind of cumbersome if you really think about it. I mean, I, as a European data subject, have to lodge a complaint with my national data protection authority. The data protection authority then has to bring it to the Civil Liberties and Privacy Office. And just like Chris said, I mean, we're talking about spies here, right? So I can't have any access really to the information or really the evidence that is being discussed if data has actually been collected about me or not. All I get is, again, this rubber stamp that simply states, well, yeah, there has been a violation, but we were able to remedy it, or no, there's actually no violation. So, I mean, it's still a bit up in the air if this ticks all the boxes.
Probably it will need time, but among all those fantastic lawyers' feelings, opinions, we are so excited to discuss it for long hours. Yes, same probably our authorities, but among this are clients, yes, who need to deal with day-by-day matters. So what does it all mean for our clients, yes, and especially when we think about this adequacy decision? Christopher, maybe we start with you.
Well, I can tell you what I'm telling my clients now, which first of all is this is still in progress. We don't know if the decision is going to be reached. If Max Schrems does push another case, we don't know what the outcome of that's going to be. So in the immediate term, everybody is still doing what they've been doing for a long time, which has been trying to use an alternate method of data transfer. It's typically something allowed by the GDPR called standard contractual clauses. those don't solve the problems with U.S. intelligence gathering. So they are of somewhat limited use. But if your data is not something where you're worried about U.S. intelligence agencies getting access to it, then frequently those will be fine. So what I'm telling my clients is just do what you've been doing, use the standard contractual clauses, keep trying to keep the amount of data that you're transferring from Europe to a minimum. Make sure that you're only transferring data that you actually need to transfer. And let's let this process play out. The adequacy decision is not going to be enough for them to change their behavior and to move away from the standard contractual clauses. They're going to need to wait until whatever happens in the EU justice system, whether it's from Max Schrems, from a local data protection authority, or whatever. They're going to be looking for some sort of final judicial decision saying, yes, this really is adequate.
Mm-hmm. Jakob, so what do you tell your clients when they want to transfer their data?
Yeah, well,
I mean,
apart from the issues with the recourse mechanisms, there are issues with the proportionality and necessity principles as well, right? Because there's a completely different understanding again of what that means in the US and in the EU. So I'm fairly likely that even if the final decision is going to be adopted, we still don't know when, probably in a couple of months, it will be subject to legal challenge. And the really interesting question is what happens in the interim, because we've already seen this with the old privacy shield, right? The moment this is being challenged in court and there are actually good arguments against keeping this adequacy decision, especially European companies might not really be encouraged to transfer data under this adequacy decision. So they might stick with the alternatives that, just like Chris said, they've already implemented, which are really take a long time to implement. We're talking about standard contractual clauses, we're talking about binding corporate rules, right, which not only apply to transfers to the US, but really all over the world. And don't forget about transfer impact assessments, which are really hard to perform and carry out. So, I think we're not yet at the point where I can tell my client to sort of breathe a sigh of relief. But this is definitely something that if it is adopted, legal challenges will take years to come to a final decision. This will certainly facilitate transfers from the EU to the US. I wouldn't feel comfortable telling my clients that they can simply rely on the adequacy decision instead of alternative means and tools of making sure that transfers to the US are being carried out lawfully and fairly.
So take a breath and wait. Yes.
Yeah.
Time and patience, as people say, is important to maybe one day we will face this some kind of contract maybe between even those two destinations to allow transfer easier. For the last but not least, if you have the one best piece in reference to data protection from a lawyer, what it will be? As personal data are an asset right now. They are very wealthy. So what would you say?
So what I am seeing in the US is a growing acceptance by companies of kind of the European view of privacy. The idea that companies should not be collecting data that they don't actually need to accomplish a legitimate purpose. The idea that people should have a right to know what's going on with their data. The idea that you should not have data kept for longer than you need it to. Those ideas are slowly taking root. They're being developed into companies' actual privacy practices. Now, a lot of this is happening because of issues with the Privacy Shield, because of all the things that we've been talking about. But we are seeing, at least at the company level, growing acceptance of the realities of what they're going to need to do to protect personal information. That's all a very good thing. At the intelligence level, the signal gathering level, the spies, who knows? It's impossible to tell, because these are all secret. Now, I've paid attention to various folks in the U.S. who have been in the intelligence gathering business, and they will quickly point out that a lot of the data that is collected in the U.S. Has benefits well outside the boundaries of the U.S. So U.S. signals intelligence is sometimes passed to European countries and used to thwart terrorist activities there. And they'll also point out, this seems a little unfair because European intelligence gathering organizations are doing many of the same things that we are. So trying to control the U.S. intelligence apparatus is who knows how that's going to happen. I think if the adequacy decision ends up either not happening or being overturned, I think we're going to have a broader discussion between the U.S. and the EU about maybe an alternate approach to this that may involve an actual treaty, as opposed to the U.S. trying to do something which the Europeans find adequate. So I don't know if that's going to happen, but we'll see.
Yeah, we'll see. Jakob, for the end, would you like to say one piece of advice for anybody who released their personal data somewhere? What would you say?
One piece of advice for people who
release the personal data, I don't know, somewhere on Facebook or somewhere else, or other communicators in emails when booking at a hotel. What do you advise people in a situation like this?
Well, I think for starters, to be mindful of the fact that you're actually publishing personal data. Now, simply giving away a name might not be that impactful, but when we're talking about personal data, we also have to consider the capacity, especially now with the implementation of more and more smart algorithms, of enriching that data, collecting it, combining it, right, and really getting a feel of your personal life. So we're talking about data that is not just personal, but really more than personal, because it really can give people an insight into your most intimate thoughts, your deepest concerns, maybe. So one advice that I would give is to be especially mindful of publishing, when we're talking about Facebook, pictures of your family or you in your home, about your vacations, right? I mean, all of that data can be combined. I mean, we hear about cases constantly of people actually being able and coming back from their vacations and having their stuff, seeing that someone broke into their house and actually got all their stuff because they realized, simply following their Facebook profile, that they would be on vacation and they knew exactly where they lived and how to get to them. So this is on a personal level. For companies, I would say, when it comes to personal data, need to be especially careful and improve their cybersecurity protocols. Since the pandemic, cyber attacks have increased, I think, by 300% worldwide.
Yeah, that's true.
even smaller companies need to start thinking about how they use data, where they store it, if they're creating backup files, and be very mindful of that.
Okay, thank you very much for today. It was lots of useful information, lots of knowledge, lots of experience from your side and from different perspectives. So thank you for your time and hope to see you next time somewhere discussing interesting legal topics.
Great, thank you.
Great. Well, thank you.